The only people who don't want to disclose the truth are people with something to hide.
Welcome back, Mario. Thank you. I hope you enjoyed our commercials while listening to us. So, Mario, we want to go right now to the case that you're talking about before we broke off.
Yes. Okay, now, if we look to the Naturalization Acts, okay, see, before that, the states had decided who were their citizens.
Right.
And they used either their statutes or the English common law. See, that's where a lot of confusion comes in, because later on, when we try to figure out what's going on, there's no significance given to the Naturalization Acts, and it's all the courts, like, for example, even Justice Gray in Mark, he looks to the English common law to construe the 14th Amendment. Now, not to be confused with the Natural-Born Citizen Clause,
right?
Because in Mark, he distinguishes between the two, between a natural-born citizen and a citizen of the United States at birth. He distinguishes that. But anyway, what happens is the confusion is that the states did follow the English common law jus soli. You know, first of all, they had their own naturalizations. They made their own citizens. But all that stopped when 1790 came around and Congress legislated into the area. They took away from the states the power to naturalize, okay? And they also imposed on the new national government who was going to be a citizen of the United States. So citizens could continue to be made by the states at birth, not after birth, because they had no naturalization power, but they could continue to make their citizens. So that's where this confusion comes in about jus soli, because they could actually continue to apply the English common law in the state as a concept and continue making state citizens. But
now, before you go further, we have to make sure our audience understands what jus soli is. I teach immigration law at the University of Georgia, so I know what jus soli means. Do you want to explain that for people who have no idea and don't speak Latin?
Well, yeah, jus soli basically means that you acquire your right to citizenship from the soil on which you were born.
Correct.
Soli meaning soil. Mm-hmm. Versus jus sanguinis, again, another Latin word, meaning that you acquire your citizenship from the parents,
right,
to whom you were born. That right there is the basic division that's been around ever since the beginning of time.
Right, and in the U.S., we have variations of both of those to become a citizen.
Yes, exactly. We use both to become a citizen.
But not every country does.
Yeah, now that's very important when you said that. You said to become a citizen.
Right.
Because we have natural-born citizens and we have citizens. So you can become a citizen any which way Congress tells you could become a citizen. There really is there's no limit on its naturalization powers.
Right.
And if you look at history, Congress, one minute you were a citizen, the next minute you weren't. For example, that happened with people born out of the United States. Again, in the early years, if you're born out of the United States to citizen parents, you were a citizen of the United States. Okay, except, again, in 1790 they had said natural-born citizen, but then they changed that. But then later on, Congress in 1802 says, no. If your parents are not a citizen as of 1802, in other words, if they became a citizen in 1803, for example, and you were born out of the United States, you're an alien. You're an alien. So that didn't change until 1855, which is a fascinating thought because you think, wait a minute, like we have people arguing that Ted Cruz is a natural-born citizen. Okay? Now, if Congress can make him a citizen, not a citizen, how could he be a natural-born citizen if Congress has that kind of power? That even at one point in our nation, he was an alien. He was an alien if his parents were not citizens as of 1802. Okay? So now let's get back to the. There's so much information. Let's get back to the point about the Naturalization Acts. Okay. The Naturalization Acts have been misread, misconstrued, unbelievable. They've been hidden in our history. They've been hidden. If you look at it, it says very simply, okay, the children of any person who becomes naturalized shall become a citizen at the time that the parent naturalizes and when he's dwelling in the United States. Okay, now what does that mean? That is so important to understand that. What the founders are telling us is that if you're born in the United States and if your parents are aliens, you're not a citizen. You're not a citizen. You don't become a citizen unless your parents, which back in history it was the father, because the mother followed the father. Once the father naturalizes, so that his wife becomes a citizen and so do his children. But they got to be dwelling in the United States for a minor dwelling.
Let me stop you there. I actually have it in front of me, so let's read that slowly again. People understand what this says. So the act initially starts out by saying who can become a citizen, what the term is, be for 2 years, you have to be sworn in, show you're a good person. Then it says, and the children of such persons so naturalized, so you took a naturalized citizen, dwelling within the United States, being under the age of 21 years at the time of such naturalization, shall also be considered citizens, period. Next sentence, and the children of citizens that may be born beyond sea, which I assume means beyond the sea, or outside the country, or out of the limits of the United States, shall be considered as, quote, natural-born citizens. So what this is saying, what you're saying here is, if your father is a citizen, and no matter where you're born, you are a natural-born citizen. That's what this says, right?
Yes, it's 1790. Shall be considered as.
Right.
Because this is a naturalization act.
Correct. So
that's another issue, but go ahead.
Yeah, so this is saying, okay, it first talks about establish uniform rule of naturalization, then it says what are the children of this person. Because if the children were also aliens when dad naturalized, by act of law, they became U.S. citizens when dad naturalized under the age of 21.
And if they were dwelling in the United States.
Right.
That's very important.
And it says if the children are citizens of the United States that may be born beyond the sea shall also be considered as natural-born citizens, provided, because there's always a proviso, right? These were lawyers, after all, that the right of citizens shall not descend to persons whose fathers have never been resident in the United States.
Right, yeah. And that was for the children born outside the country. They want the father to be a resident, you know.
But then ultimately it says that no person heretofore prescribed by state shall be admitted as a citizen except by act of the legislature. Because you're right. States were granting citizenship at the time.
And we have proof of that, absolute proof.
David's got a comment, though.
Yes.
Yeah, we got to have some unlawyer comments here. There is a bottom line to everything you and Charles are talking about, and it's one word, and that's allegiance, correct?
Yes, that's the reason for all this, allegiance. That's really the driving mechanism.
But do you think that this manner that you're saying to require people to be natural-born citizens is the best way in this day and age to determine someone's allegiance? Because I could come up with 4 or 5 different scenarios that would satisfy what you say as a natural-born citizen, which would call someone's allegiance into question. And I think that, David, you bringing that up is a really good point, because that's overall you're trying to get someone to be president or run for office who is loyal to this nation. And
only one nation.
No, only to this nation, right? To one nation. And while, Mr. Raposa, your argument is very succinct, very clear, and logical and legally correct, I don't necessarily know if it's the best way to determine allegiance in this day and age where people's mobility is so people are way more mobile now, and I David bringing that up is a really good point, because that's what this is all about at the end of the day.
May I address that?
Of
yes,
course,
please.
Absolutely.
Okay,
That's what you're on.
Yeah. Okay. First of all, I would argue that you've actually made my case stronger.
Okay.
By saying that in this day and age we have more mobility. So we have more aliens, more people from different countries, more cultures, more foreign ideas, so on and so forth. In America, we have more. But if we want to maintain what was established as the core value of being an American, which again is what the Revolution was about, what the Constitution is about, then you've got to take a snapshot and see what were the values then versus what were other values in other countries, and you want to maintain the United States, basically as a grand principle, as a republic. Okay, which basically means you don't want a monarchy, okay? And then, of course, the idea of representative government and the rule of law and the freedom of religion and freedom of expression. I mean, those are all, privacy, the right of privacy. I mean, these are all basic American values which you want to maintain.
Absolutely,
okay?
But my question is as to someone's allegiance, is this the best way to determine what someone's allegiance here? Because like I said, I can come up with plausible scenarios that someone would satisfy your natural-born citizen test, but on the face of it, it would appear that they weren't necessarily aligned with the interests of this country, and that's what my overarching question is. Is this the best way to determine someone's allegiance, or is that determination best made in another way, or are we just stuck with the lesser of two evils here?
Okay, I had given you point number one. Here's point number two, which addresses that, okay? Now, when the Constitution was made, that was it. It was made. The people spoke. Okay, they made a policy decision. That's the law. That's the law of the land. That's it. If you want to change that, then you do it through a constitutional amendment, because you say, well, our society has evolved and there are different circumstances, et cetera, et cetera. Therefore, we will change that. You can't just say, oh, well, it's different today, and maybe. Because you can do that with everything.
No, I agree with you, Mr. Buzzo, that this is the law. I'm saying should we, and I believe that if we do change it, there should be a constitutional amendment.
If I'm not mistaken, Senator Hatch wanted to change it a couple of years ago to get Arnold Schwarzenegger to be president.
To be president, right?
And he did, didn't he? He talked about it.
He did, and that's my question, Mr. Buzzo. Is that something that you would be in favor of, or policy, as a matter of policy, would you be in favor of? Looking to a constitutional amendment to determine a better way, simply because your test disqualifies many people who are otherwise qualified and whose allegiances aren't in question at all.
No, I would not be in favor of it, because first of all, when the courts decide a case, okay, they decide it based on law. And what is law? Law is something that already exists. Okay, their jurisdiction comes into being because they have a set of rules, pre-established rules that they're supposed to follow. They're not supposed to make the rules to fit a certain situation if they can avoid it. Okay, now I'm assuming that the law is clear enough that there's no gap of some sort, that it's not unprecedented and you got to make new law type situation. But if the law is there, you don't adjust the law to fit candidates because he's a nice guy. I knew his father. I knew his mother. He's an honest man. You can't do that.
But sir, that's not what I'm talking about in this context. I'm talking about, I agree with you that this is what the law is, but there's nothing prohibiting an amendment to the Constitution when we determine that the Constitution does not function the way we want it to. If a better way to test someone's allegiance is determined through a constitutional amendment process, what would be the problem with that? There's absolutely nothing legally incorrect about changing a law or the Constitution to fit our purposes as a people. I'm not talking about for individual candidates, but I'm talking about for the overall betterment of the populace in determining someone's allegiance.
Well, to take that point a little further, could Congress pass a law that says what natural-born citizen is?
Very fascinating question, okay? My argument has been from day one that it cannot. Okay. It cannot. For different reasons. First of all, the citizens made the Constitution. The Constitution did not make the citizens. Mm-hmm. The citizens created the nation. And, of course, the natural-born citizens, they are the ones who Vattel calls them the true citizens, okay, in the sense of that they have the highest allegiance. Now, that's not to take away from people who are not natural-born citizens. They have all the same rights as the natural-born citizens, except they can't be president or vice president. But, Congress only has power to naturalize under Article 1. That's it, naturalization. Now, of course, I know what the courts do. They look for everything under the sun to try to expand powers that are listed there, to give the government more power. Implied powers, necessary and proper, and you go on and so forth, okay? Now, the question is, can you argue for an expansion of Congress's naturalization powers to go as far as creating a natural-born citizen? Can you do that in good conscience, based on principle of some sort? I thought about that, and I say, it doesn't make sense to me. If they could only naturalize, how can you make a natural-born citizen? So that's been my point all along. They do not have the power to define a natural-born citizen. They can confirm what a natural-born citizen is based on what the law is, and then if you have a problem, I think it's up to the courts to decide whether Congress is right or wrong.
Well, and in fact, Congress actually, when it passed the declaration SR 551, saying John Sidney McCain III is a natural-born citizen of the United States. So Congress has done this already, at least in McCain's case, in 2008, defining what it is. I mean, that's never been tested in the law. We want to come back and keep talking about this, Mara. This is awesome, awesome discussion. We're going to take a break here on America's Web Radio.
The only people who don't want to disclose the truth are people with something to hide.